Much for that. At the same time, the Court of Appeal has declined to lift orders of the High Court that pronounced the health laws unconstitutional that would have given effect to, among other policies, a new health insurance scheme. The court has instead ruled that the matter will have to wait for determination on the validity of the orders of the High Court, which had also stayed its orders for 45 days to give the government time to comply. Let's get more from our very own Stephen Little.
President William Ruto's health plan remains on its sickbed. Attempts by the government to have the High Court orders lifted have been delayed further. Court of Appeal Judges Francis Tuyot, Lydia Achode and Abida Ali noted that there is a risk that should the Court of Appeal agree with the High Court's judgment in its entirety, the public harm will be greater and more costly. They noted that there is no crisis as pointed out by petitioners, since there is a transitional clause from the NHIF scheme, which is still operational. The High Court last month, through a three-judge bench constituting Justices Alfred Mabea, Robert Limo and Frida Mugambi, ruled that there was no public participation in coming up with a new healthcare program. The court ruled that the Social Health Insurance Act 2023, the Digital Health Act 2023 and the Primary Healthcare Act 2023 stood unconstitutional, null and void. This prompted the government to quickly move to the Court of Appeal to have the findings set aside. The judges at the High Court noted that there were disparities in the new Social Health Insurance Act, since it will burden a few salaried individuals by creating a disparity in the contributions. The three-judge bench directed that Parliament should undertake adequate public participation in accordance with their constitution before enacting the three laws. The court allowed Parliament 120 days to correct the anomaly beginning July 12, even though the same court stayed the findings by a further 45 days. The judges further noted that various clauses in the Act offended Article 43 of the Constitution, which obligates every Kenyan to be uniquely identified for purposes of provisions of health services. The Court of Appeal judges returned to the bench on 20th September to give verdict on whether it will stay the High Court orders or not. Stephen Little, Citizen TV.
All right.